Good morning, everybody. Hope everyone's having a good, happy St. Patrick's Day, and everyone's wearing some green today. Not getting pinched by anybody, but we appreciate your participation and joining us on this Zoom call today. Today, we're going to be talking about funding your trust and how important it is to fund the trust. Right now, you should be seeing me, and then you should be seeing our screen here. And what we're going to do is we're going to share my screen, and fingers crossed that technology works and everything shows up okay. But we want to make sure that you understand the importance of funding your trust and how to fund the trust and what assets go in the trust and how your trust works in regards to each individual asset that you have. So hopefully this helps out. And then once again, just as a reminder, on your Zoom, you should have the ability to ask questions. At the bottom, there should be a chat. And if I can get Elisa here to, there should be under your thing a little chat box that allows you to type in questions. We're going to save questions until the end, but you can certainly type those in as I'm going through this, and then we'll go through those questions at the very end, make sure we address everybody's questions today. We also have another drawing today, so one lucky participant was going to win our gift basket today. So all of you that are in attendance are going to be put in that drawing for our gift basket. So we'll do that at the end as well. So let's get started. We're going to do our screen share here, and hopefully you guys all see my screen. This is just it's a whiteboard, and so you should be able to see now as I start to draw on my screen. Hopefully you saw that little scribble, and I'll erase that. But funding the trust. The number one reason why trusts fail, why they don't work, is because people don't fund the trust. They don't put their assets into the trust. Looks like we have somebody that's waiting to get in. It's because people don't fund the trust. And a lot of the questions that I get oftentimes from clients is, well, what types of assets should I put in the trust? Do I put my car into the trust? Do I put my checking account into the trust? Do IRAs go into the trust? Do annuities go into the trust? So hopefully today will be a good, just kind of comprehensive overview of all of your assets, almost all the assets that people would own, and how those assets should work in regards to the trust. So let's do just a quick overview here. Remember, we created this instrument for all of you that are on this call, maybe some of you that are on this Zoom call aren't clients, maybe you don't have a trust, and so this is just kind of good review of how a trust works for you as well. But we created this instrument that's called a revocable living trust, and the main purpose of the trust is to keep us out of something called probate. Okay, so that is our number one goal with the trust, is to keep us from going through something called probate. And the only way it does that is by owning all of your stuff. We're going to call those things assets. And so the trust, once it's created by your estate planning attorney, these things need to be retitled out of your name into the trust name. So before you created the trust, your bank accounts and your house and your cars and your checking and all those things were titled in your name, or if you were married, yours and your spouse's name. After the trust is created, then we retitle those assets out of your names and into the trust name. So the trust becomes the legal owner of all of this stuff. And that, by simply doing that one thing, taking ownership of this stuff, getting it out of your name and retitling it into the trust name, we avoid probate. And that saves us money, it saves us time, it saves us expense and aggravation and stress and publicity, all the bad things that go with probate. So it's very important that we fund the trust. So anytime you hear an attorney say, we got to fund the trust, that's what we're talking about, is retitling these assets that you own out of your name into the trust name. So the trust becomes the legal owner of these assets. So let's talk about your assets and what types of assets you will typically own and how those assets work in regards to putting them into your trust. So the first major asset most people own, of course, is real estate, or we'll just call it your home. And when I say home, that could also be a a cabin, it could be a vacant lot. It's any real estate, any real property is what we're going to talk about in our first category here under home. And so real estate, when we own real estate, we have what's called a deed, and that's what shows ownership is the deed. And so when we go and we buy a home, we get a deed that shows that I own the home, or if my wife and I bought the home, it shows joint tenancy, usually with rights of survivorship, or it may say community property with rights of survivorship on the deed, which means if I'm single, I own the home, or if I'm married, my wife and I own the home. And we don't want that, because if death or incapacity occurs, then we have to go once again through something called probate, which is what we're trying to avoid. So instead, we want to take the deed. Remember, the deed is what shows legal ownership for a piece of real estate. So we want to take the deed, we want to do a new deed and get it out of our names and put the deed into the revocable living trust. And how do we do that? We prepare a new deed. And so your attorney would prepare the deed transferring ownership of the home into the trust out of your name or yours and your spouse's name if you're married. And that way, then the trust becomes the legal owner of the home. Same thing with a second house or a vacant lot, any type of real estate. This is how it works. We have to do a deed to transfer ownership into the trust. If we have property that's, let's say we have a home here in Arizona, we have a vacant lot up in Flagstaff, we have a rental home in Southern California, and we own some farmland in Iowa. Can we put all of those into the trust? Yes. How do we do that? A deed. So all of those would have a deed, and we just need to deed those properties out of your name into the trust name. And then the trust becomes the owner of the Iowa farm, the rental property in California, the vacant lot up in Flagstaff, and the home here in Phoenix. And then we avoid probate by doing that. Can your Arizona trust own property outside the state of Arizona? Yes, it can. There's no problem with that. How about if we have property, real estate, outside the United States? Let's say I have a piece of property in Rocky Point. We go down there every spring break, and I own a house down there. Let's say we have one of those. Can we put foreign real estate into our United States trust? Typically, no. And so we never want to transfer foreign real estate into a United States trust. That usually causes tax problems and stuff. So we typically don't want to do that. So if you're a Canadian citizen and you're down here part of the year, can we put your Arizona home into your trust? Yes. How about your home in Vancouver? No, we should not be transferring your Canadian real estate into your United States trust. That can cause tax problems. But any real estate in the United States, no matter what state it is in, Alaska, Hawaii, Florida, whatever other state, we can always transfer that into your Arizona trust. And that's what keeps us out of probate. So that's real estate, and that's how that works. If there's any questions on that, once again, just type it in the chat box and we'll address those at the end. The second type of asset that most people own is what we're going to call non-retirement accounts. What is a non-retirement account? A non-retirement account, an example of that would be a checking account or a savings account or a brokerage account, mutual funds. Those are all CDs. Those are all non-retirement accounts. So what is typically the rule with these types of assets? How do they work with the trust? How do we get them into the trust? Does the trust become the owner? Do we put beneficiaries on these? How does that typically work? Typically, the rule is with non-retirement accounts like checking and savings and brokerage and CDs and money market accounts, the rule is we want the trust to become the owner of these accounts. So we change ownership. So before you have your trust created, the owner of these types of assets is typically you, or if you're married, it's you and your spouse. And typically, after you create your trust, we're going to change that. So now the trust becomes the owner of these types of assets. So how do we do that? What's the process we go through to do that? We go into Wells Fargo or Chase or Bank of America or wherever it is you have these accounts, Fidelity, Vanguard, wherever it is you have these assets, and we tell them to retitle ownership of these assets from your name to the trust name. And then they'll retitle those accounts into the trust name. How do you know that they've actually retitled the accounts from your name to the trust name? You want to get written confirmation from each of these individual institutions that says, we have retitled account number 1, 2, 3, 4, 5, your savings accounts at Wells Fargo, from Mr. and Mrs. Smith to the Smith Living Trust. And that way, you know that that savings account is now owned by your trust. And then what you should do is take that confirmation, that letter you got from the bank, and put that letter inside your trust binder. There's a tab inside each of your trust portfolios, that big burgundy book, if you still have your burgundy book from Morris Hall, or if you've updated your documents since I've left Morris Hall, it's now a gray binder, or a white one. We have white or gray. You take that confirmation, you stick it inside your trust portfolio. Why do we do that? Well, because when you die or become incapacitated, the number one question that's going to be asked of your successor trustee is, what are the assets and how are they titled? And your child or your brother or sister or neighbor or whoever you've listed as the trustee of your trust is going to look at me and say, I have no clue where my parents or friend or whoever this person is to you, where they banked. I don't know where they have their assets. And then it becomes a question of, how do we figure that out? If you've kept everything up to date and you've put these confirmation letters inside your binder, then it's very easy to figure out, oh, we have a checking account at Wells, we have a savings account at Bank of America, we have a brokerage account at Fidelity, and that then makes it easy to gain control of these things when you die or become incapacitated. So we want a nice clean record of what you own and how it's titled inside your trust portfolio in your binder. And these assets will change over time. Today in 2021, you may have a checking account at Wells, and 5 years from now, you may close that account down and move that money to Bank of America. Well, you're going to want to make sure you've updated your trust binder with that information to show you no longer own the account at Wells, and now the account is at Bank of America. And that will make things a lot easier for your successor trustee when they need to take over after you die or become incapacitated. One of the main questions we get with non-retirement accounts is our checking accounts. A lot of times people will say, well, Dave, I was told not to put our checking account into our living trust. And that is sometimes true. And my response always to that is, it depends. It depends on the size of that checking account. I have some clients that like to keep $50,000 or $60,000 in their checking account. If we keep that kind of money in the checking account, then we should have that checking account owned by our trust, because we potentially have a probate problem if the value is too significant. So it comes down to value, right? Now, most of us don't keep $80,000, $70,000, $50,000, $60,000 in our checking account. Most of us keep a few $1,000s in our checking account, and we keep enough in there to pay the bills, and then we replenish that account every month to pay the bills every month. And so if we keep $5,000 to $10,000 in our checking account every month, and then it goes down, and then we replenish it, then you can keep that checking account in your names. You don't need to put that in the trust. And this is the primary reason why. It's not, I want to be clear, it doesn't hurt you if you did put the checking account into the trust. And so if you're saying, oh, Dave's saying I only have $10,000 and don't put it in the trust. That's not what I'm saying. If you've put that checking account that has $5,000, $10,000 in it in the trust already, not a big deal. That's fine. It's not like it's going to hurt it. It's fine to do that. But if you have a $5,000 to $10,000 checking account that's not in your trust right now, do you have to put it in your trust? No. And this is what would happen if you did put it into the trust. Wells Fargo, Bank of America, Chase, when you transfer that checking account into your trust out of your name, what they're going to give you is a new account number. So they're going to delete your old account and they're going to give you a new account number. Well, when they do that, then all of your automatic withdrawals and deposits you have coming in and out of that checking account have to be reset up, which can be a pain in the backside. So instead of doing that, you might just decide, well, it's only $5,000 to $10,000. It's not going to cause a probate problem if I die. Why? Because the probate threshold amount in the state of Arizona is $75,000. What does that mean? It means if we have a total combined value of assets that are not in the trust, like let's say I have 5 assets that are just in Dave Eastman's name, not the Eastman Living Trust. And the combined value of all 5 of these is $60,000. And I die. Does my wife have to go through probate to gain control of these assets? No. Why? Because 60 is less than 75. And this is our probate threshold amount, 75. So if we have a $5,000 or $10,000, $15,000 checking account, and that's really all I have that's not in my trust, when I die, then there still is no probate because we're under the probate threshold amount. So just keep that in mind with checking accounts and how those would work. But these other assets, like our savings account that might have $100,000 in it, that should definitely be owned by our trust. Our brokerage account that may have a couple $1 million in it, that should definitely be owned by our trust. So the ownership should be transferred from us to our trust, and then we get written confirmation from the financial institution saying that that's been done. We take that written confirmation, we stick it in our trust binder as a record for our successor trustee to have. Hopefully that answers any questions that you might have in regards to non-retirement accounts and how those work. The third major asset that clients typically own is retirement accounts. Okay. So what is a retirement account? Well, that's an IRA. That's a 401k if you're still working. It's a 403b is another type. Okay. So these are all retirement accounts. A retirement account is distinguishable from a non-retirement account in that a retirement account, we put money into these things, income tax free. We didn't pay income tax on it when it went in. And it's been sitting in here growing in these income tax deferred, meaning we don't pay income tax until we pull the money out of these, which up here, these, a checking account, the money goes into your checking account after you've already paid tax on stuff and it's not growing income tax free and all that. We pay income tax on those things like savings and brokerage. These are different than that in regards to how that's taxed over time. So how do retirement accounts work in regards to the trust, and how is it different than non-retirement accounts? Well, remember, non-retirement accounts, the rule is we change ownership. We change the actual owner, just like on the real estate. We change the owner from us, remember us on the non-retirement, to our trust. And our trust becomes the legal owner of the non-retirement accounts. For retirement accounts, we never, ever have the trust be the owner. So that's the major difference. A trust never, under any circumstance, is the owner of a retirement account, unlike a non-retirement account. So then how do retirement accounts work with the trust? If it's not the owner, then how does it work with the trust? Well, retirement accounts are made up of, see if I can get my screen to give me a little more room here. Retirement accounts are made up of really three different parties. Every single retirement account is made up of three parties. You have the owner, you have the primary beneficiary, and you have a contingent beneficiary. Every single retirement account, IRA, 401k, 403b, these are all the same. So the owner is the person that owns the IRA or 401k or 403b. The primary beneficiary is who gets the IRA, 401k, 403b when the owner dies. The contingent beneficiary is who gets the IRA, 401k, 403b when the owner and primary beneficiary die. It's just a backup beneficiary. So what's the rule on who our owner should be, primary beneficiary should be, and contingent beneficiary should be when it comes to having a revocable living trust? Well, remember, we just said the owner is never the trust. That never happens. The owner is always you, the person that owns the retirement account. And that will always be that way for the rest of your life. And the reason why is tax reasons. We're not going to get into that today. It's not today's topic. We'll do another presentation on retirement accounts, and that takes a full presentation in itself on how those work. But just understand the owner of a retirement account is always you. The primary beneficiary is who, once again, receives the retirement account when the owner has died. So who can our primary beneficiary be? Well, if we're married, our primary beneficiary typically, I didn't say always, but typically is going to be your spouse. So if this is a first marriage, I've been married for 45 years, I've got $1 million IRA at Charles Schwab, we've got joint kids, that kind of a situation, then typically it's going to be your wife or your husband that is the primary beneficiary of your IRA. Meaning when you die, the owner, your $1 million Charles Schwab IRA will go to your wife or your husband, depending on whose retirement account it was. Once again, the reason for that, tax reasons, we'll have a whole nother presentation on why, but just understand that that's how that typically is done. Now we're just left with the final person of every retirement account, which is a contingent beneficiary. Remember, the contingent beneficiary is just who gets this retirement account when the owner and primary beneficiary have died. So then who is that? Well, you have a lot of options when it comes to the contingent beneficiary. You could name your children, if you have children, as contingent beneficiary. You could name a charity as your contingent beneficiary, or you could name your revocable living trust as the contingent beneficiary. So when does it make sense to make the trust the contingent beneficiary instead of your children, your charity, your brother, your sister? That comes down to a word that says it depends. Okay, so there is no hard and fast rule when it comes to should the trust be the contingent beneficiary of your retirement account. And the reason why is because it depends on what you're trying to do with your retirement account. If you came in and saw me and you said, Dave, my wife and I have been married now for 45 years. We have $1 million IRA at Charles Schwab. We have no children, and we are philanthropically minded. We want our entire estate, everything in our trust, and all of our retirement accounts to go to our favorite charity, Sun Health Foundation, when we die. Then I would tell that client, okay, so the trust will be drafted to say, when the two of you, Mr. and Mrs. Smith, my clients, you die, then all of the assets in the trust, your non-retirement accounts and your house and your vacant lot, and all the stuff the trust owns, is going to go to your favorite charity, Sun Health Foundation. Okay. But we don't want, in that scenario, to have the contingent beneficiary of the IRA or 401k be trust. Why? Because if we want all of our stuff to go to charity, the best thing to do is name on your IRA beneficiary form or 401k form, name as the contingent beneficiary directly Sun Health Foundation. Why? Once again, tax reasons. It all has to do with taxes. These are very tricky assets when it comes to taxes. And if you make this pay here and it passes through here and then goes to here for a retirement account, unlike non-retirement accounts and houses and everything else, it causes a tax issue if you pass it this way. Versus if you bypass the trust and leave it directly to your favorite charity, we solve a tax issue. So in that scenario, I would tell the client, don't make the contingent beneficiary your trust. Instead, just make Sun Health Foundation the beneficiary. So it depends. Now, another scenario would be, well, Dave, let's say we have a client that comes in and they say, we've been married for 55 years. We've got 4 kids. Everything we have, we want it to go to our 4 kids. We don't have any charities we're leaving anything to. It's all going to our 4 kids. Well, once again, we're back to it depends on who the contingent beneficiary should be. The owner is still always you. The primary beneficiary is still my spouse. It depends on who we list as the contingent beneficiary. And in that situation, if all 4 kids, I'm going to change this here, erase this from our charity because we're changing our fact pattern. We now have it so when Mr. and Mrs. Smith die, we have 4 kids they want to leave their entire estate to. Okay? Instead of a charity. Well, my question to Mr. and Mrs. Smith would be, are all 4 of these kids healthy? Do we have any disability issues? Are any of them special needs? Are any of them hooked on drugs? They have a meth problem, a crack problem. Are any of them spendthrifts? Do they have a problem managing money? So those are other questions I'd want to know before I said, okay, let's make the trust the contingent beneficiary. But let's run through a fact pattern and say, nope, all 4 of these kids are great, responsible, good people, make good decisions, married to good people, none of them have disability issues. Then yes, we'd want the trust to be the contingent beneficiary so that when Mr. and Mrs. Smith die, that IRA that's worth $1 million to Charles Schwab would then pay to the trust, and the trust would distribute it directly to these 4 individuals. And that does not cause a tax problem. So there's a difference between charities and individuals in regards to how the retirement accounts pay out when death occurs. Okay, so it's a complicated issue. I know you're saying, Dave, you just made my head spin and I don't know what I'm supposed to do with my retirement account now. But there's no easy answer when it comes to retirement account. It's just, it depends on who the contingent beneficiary is based on what you're trying to do and who you're trying to leave your assets to. So if there are further questions on that, it might be good just to come in. We can review the retirement account, review who your current beneficiary is, and make some suggestions on changes if we need to, or maybe it's fine. But retirement accounts by far are the most complicated asset when it comes to trusts. Everything else is easy. House, we transfer ownership. Non-retirement checking savings brokerage, transfer ownership, no questions asked. Retirement accounts, tricky. We know the owner's always you. We know this primary beneficiary, if you're married, is your spouse. It's this that's the question mark. Who should be our contingent beneficiary? And that's a depends question. So hopefully that gave you some insight on retirement accounts. My board is looking like a big scribbly mess, but hopefully some of this is making sense and resonating with you. We're going to see if we can get some more room on my whiteboard here. We're going to move to another type of asset that a lot of you have, and that is life insurance. How does life insurance work? So with life insurance, very similar to a retirement account, you have different parties that make up life insurance. So with life insurance, you have the insured. That's whose life the life insurance is based on. You have an owner, you have a primary beneficiary, and you have a contingent beneficiary. So you have 4 parties that make up every single life insurance policy. So who should these people be, and how does it work with your revocable living trust? Well, the insured, once again, this person, that's whose life the insurance is based on. So that has to be a person. The insured cannot be the trust, and trust is not a person. So if I have $1 million life insurance policy on me, then I am the insured. So it's always you, the person, that's the insured. And then when the insured dies, that's where the policy then pays out to either the primary beneficiary, or if they're dead, the contingent beneficiary. So then who is the owner? An owner can be anybody. So I can actually own a life insurance policy on my wife. She's the insured, but I am the owner. Typically, the owner is also the insured, but it doesn't have to be. But usually that's how it is set up. So that's usually what they'll do. And this is where you have to be careful with what type of life insurance it is. If it's a group life insurance policy, what is a group life insurance policy? It means we got it through our employer. So if my employer got life insurance on my life, then typically my employer is the owner. If it's non-group life insurance, which is what most people have, then the owner, when they set it up, usually like State Farm or whoever got you the insurance, typically it would be you, and you would also be the insured. But what we'd want to do, if that is the case, let's say I have $1 million State Farm life insurance policy. I bought it, it's non-group, my employer doesn't have it on me. I would want to change the owner from me to my trust. Why would I want to do that? Why would I want the owner of the policy to be my trust and not me? Well, the primary reason is because sometimes in certain types of life insurance, we have what's called cash value that builds up inside of our life insurance. Cash value is like a checking account within our life insurance policy. We can access the cash value whenever we need it, and we can spend it and access it. So the issue that pops up is if I am the owner of my $1 million life insurance policy at State Farm, and I have built up $200,000 worth of cash value in that life insurance policy over time, and I become incapacitated. I get in a car accident, I'm in a coma, I get Alzheimer's or Parkinson's or dementia, or right now COVID, and I'm hooked on a ventilator. And I'm the owner, so I'm the only one that could call State Farm and say, I need access to the $100,000 to pay for these medical expenses or to pay off this debt. I'm incapacitated, the owner, the person that owns it. So I can't do that. I can't pick up the phone if I'm hooked to a ventilator. I can't pick up the phone if I have dementia or Alzheimer's and tell them I want $100,000 of my cash value. Well, what happens if my wife calls State Farm and I am the owner and I have dementia and my wife says, I need $100,000 of that cash value? Remember, the owner is the only one that can access that information. The owner is the only one that State Farm will talk to. So that creates a problem. So instead of the person, the individual who could become incapacitated and has, human frailties that happen to us, we would want to change ownership from us as individuals to our trust. So our trust would be the owner, How does that solve these issues? Well, if the trust is the owner and I, the insured, become incapacitated, dementia, Alzheimer's, Parkinson's, COVID, and my wife now needs to access the cash value to help pay for medical expenses or whatever else. Remember, my wife and I are co-trustees of our joint trust. So if the trust owns it, my wife has access to the cash value. State Farm won't tell her, who are you? And I'm not talking to you. We need the owner in order to do any transactions. Well, she is an owner because she is a trustee of our joint trust, which owns the policy. And so that helps with that. How about the primary beneficiary? Who should receive the policy proceeds when I, the insured, die? We know the owner is going to be the trust if it's a non-group. If it's group, your employer owns it. You can't change that to the trust. If non-group, we just said your trust is the owner. Who should be the beneficiary when the insured dies? That would also be your trust. So we want the primary beneficiary and the owner of a non-group to be our trust. So let's say, once again, I have $1 million life insurance policy on my life at State Farm, and I get in a car accident and I die. So the insured is dead, me. Then we want the check, the $1 million check, to not come to over here, my wife, but instead it's going, she may be watching this saying, what, you're not giving me that $1 million? Nope, we're not. Instead, we're leaving that to our joint trust. Why? Because the trust will offer more protection if it pays to the trust than if it pays directly to my wife. What happens if my wife and I die in a car accident? Well, we want the trust to receive the proceeds that way to protect the inheritance for our 4 children that are down here. So contingent beneficiary in this case, you're not going to need a contingent beneficiary. Remember, the only reason why you have a contingent beneficiary or a backup beneficiary is in case the insured, in this case owner, and primary beneficiary are all dead. Then you need a backup. Well, if the trust is the primary beneficiary, the trust will always be there, then you really don't need a contingent beneficiary listed. So when I die, my $1 million policy pays to our trust, it comes into here. Now, while my wife is alive, can she use that and access it and spend it? Yes, because she is the trustee and she's also a beneficiary of our trust. And then when my wife finally dies, then this $1 million will go to, or if she didn't spend it all, and I trust my wife, she's not going to blow through all that. But if she did blow through it and there's something left, then what's left will end up going to our 4 children. And how our trust is set up is our 4 children will receive the proceeds from the life insurance and the house and the brokerage and the IRA. If the IRA pays to the trust, it's going to go to our kids in the form of what we call a legacy preservation trust. What is a legacy preservation trust? It means that our kids receive their inheritance in trust, in perpetuity. And that protects our child from our child in case they're minors or in case they are married to a slimeball in-law that we don't like, or in case they have some creditor issues, or we're just worried about them getting in a car accident, being sued. So we have our assets in our trust when we both die, passing to our 4 kids, and it protects them from all the sorts of bad arrow darts, that people may try to come in and take that money from them. So that's how life insurance would work. Hopefully that helps with that. I'm going to go through 2 more. How much time do we have? What time is it? 40. Okay, so a few minutes. I'm going to go through. I'm not sure if I might have run out of real estate here on my whiteboard. So I'm going to erase some stuff. We'll just go back to the top. And this, I think we're recording this, right? So we're recording this. You can, I think we're going to put it on our website, maybe YouTube. So don't hyperventilate. Don't erase that, Dave. I haven't taken notes yet. It'll be recorded. You can play it back as many times as you want and look at it. So let's go back here and see if I can erase some of this and go through a couple more assets with you before we end our presentation and open it up for some questions. So we talked about life insurance. Our fifth asset that our fifth asset, what happened? Screen sharing is stopped as the shared window is closed.
Did we accidentally close it?
Let's see, let me open it again.
Okay, I'll let you.
If we lost you, hopefully I can get us back up. If not, I'll just talk about it and we'll do it that way. Sometimes technology can be a little touchy. Give me 1 minute and see if we can get this to open up. And if not, okay, let's see. Hopefully you're still looking at my whiteboard. I'm gonna have Elisa just do a quick, we need to go here. Oops, hopefully I didn't end Zoom. Oh, is that Zoom?
Yes, where is that?
Okay, there we are. So doing a share screen, sharp pen. Okay, looks like we're back up here. Sorry about that. So the next asset we're going to talk about is going to be annuities. Some clients have annuities. And so how do annuities work? Well, annuities are very similar to retirement accounts. Okay, so you have to be very careful with annuities, just like retirement accounts. And with an annuity, you have different parties that make up the annuity, just like a retirement account. You have the annuitant, you have the owner, you have the primary beneficiary, and you have a contingent beneficiary. So like life insurance, the annuitant is just a fancy legal word that means the person whose life the annuity is based on. Like in the life insurance, it's the insured. So this is the annuitant, and that's always going to be you, just like on the insurance. The insured was always you. The owner of the annuity, we typically want the owner to continue to be you, unlike in the life insurance part, where we had the owner be the trust. In this case, with the annuity, it's like a retirement account most of the time. And so the owner would typically be you. And then the primary beneficiary is typically your spouse if you're married. If you're not married, then the primary beneficiary, it comes back to it depends thing, just like retirement accounts. And the contingent beneficiary is just like retirement accounts, it depends. And what does it depend on? It depends on what type of an annuity we're talking about. Is it a qualified annuity? Is it a non-qualified annuity? What are the death benefit options? Can we stretch it out after death has occurred, or is it a lump sum payment? Does it continue on the life expectancy of the annuitant? Can we annuitize it after the annuitant has died? So there's lots and lots of questions that go into annuities, very similar to retirement accounts. So these are kind of finicky assets. You have to be careful with those. Why? Because if they're qualified annuities, meaning tax issues go with them, then we have to be careful with that. So just keep that in mind. Just like with the retirement accounts, if you have annuities and you're saying, okay, well, you didn't really answer how I'm supposed to take care of my annuities with my trust, it's because it depends. And we don't want to just give you an answer that doesn't make sense. And so you might need to come in, we'll do an evaluation of the annuities, figure out what kind of annuities they are, and then I can give you a better recommendation in that regard. So annuities, retirement accounts, you have to be careful with those. The next type of asset would be vehicles. I get this question almost once a day. I was told by our estate planning attorney I should never put my vehicle into my trust. I should never put my car into my trust. I get that all the time. So if I'm driving an S-Class Mercedes that's worth $85,000, should I put that car into my revocable living trust? Well, remember, our probate threshold amount is $75,000 cumulative. Well, I have one asset by itself that is greater than our probate threshold amount, which means if I don't put my S-Class Mercedes into my trust and it's worth $85,000 when I die, then in order for my wife or my kids or my loved ones, whoever, to gain control of this vehicle and sell it or retitle it, they have to go through what? Probate. Okay. So when I get the question, should I put my car into my trust? What kind of a question is that? It's a depends question. Depends on what? Depends on the value of our car. Now, if we change this fact pattern and we say, well, Dave, I'm not driving an S-Class Mercedes. I'm driving a 2015 Honda Accord. It's worth $25,000 and it's depreciating in value every single year by $5,000 or whatever. Do I need to go to the DMV and wait in line for 20 hours and then convince the person at the DMV that I can put my car into my trust? No, you don't need to do that. Why? Because we have a probate threshold amount of 75. So if I keep my Honda Accord and my $10,000 checking account out of my trust, then when I die, I have $35,000 that's in Dave Eastman's name. And this number is less than this number, which means no probate. Okay. So vehicles, should we put them in the trust? It depends. What's the value of your car? Now remember, if I have 5 cars and the total combined value of all 5 cars is greater than 75, I need to put some of those cars into my trust to minimize our potential probate issue. Now, the DMV does have beneficiary forms that you can go to the DMV and fill out. It's it's a form that they have that says when the owner of the vehicle dies, you can list a beneficiary that says the car goes to my son Johnny. And then all Johnny has to do when death occurs is take a death certificate into the DMV or a third-party DMV dealer, and they'll retitle the vehicle into Johnny's name without having to go through probate. So you can also do that instead of transferring it into the trust. Do the beneficiary form that just pays to that kid when death occurs, if you want it to go to one of the kids. But if you want the car, to be part of the whole pot, part of the sale proceeds of the home and the checking and the savings and the brokerage account and all that other stuff that pays to the trust, you want the car to be in here to be sold, and then everything in here goes to your 4 kids, then you may want to transfer ownership of this into the trust to have it be part of the trust. But those are a couple of ways you can deal with the vehicle on that. I think those are all the major assets. I'm trying to think if there was another major asset that most clients own. The only other major things, you may have individual stock that's through like Computer Share or BNY Mellon or something like that, a trading company. That's very similar to non-retirement accounts. We'd want to transfer ownership of that stock to the trust. So the owner of the stock would be your trust. Just so you are aware, everybody that's on this Zoom call today, when death occurs and we own individual stock, let's say I have individual Verizon stock. It's not in my brokerage account. It's individual stock that I own, and it's through Computer Share. This stuff becomes a nightmare to administer when death occurs. Why? because computer share requires a bunch of forms with a certain kind of a stamp. It's called a medallion signature stamp that you have to get. And it's a two-step process. You have to get a medallion signature stamp to retitle the asset into the new trustee's name. Then you have to get another medallion signature when you want to liquidate the Verizon stock to distribute it out to our 4 kids. It becomes quite the chore. And now with COVID, most of these people that work at these financial places are working from home, and it becomes even more of a hassle to try to get everything done. So my advice is, if you have individual stock right now that's sitting out there, I have some Verizon stock, or I've got some AT&T stock that's not in my brokerage account with my financial advisor. It's individual stock shares that I have. If you want to save your successor trustee a lot of pain and anguish, go and take that stock and give it to your financial advisor and have them put it in your portfolio as part of your brokerage account or something. Otherwise, this stuff becomes quite a chore to deal with when death occurs. It doesn't go through probate if it's owned by your trust. It's just the requirements that computer share, the hoops they make us jump through to get this stuff liquidated, even though it's in the trust. It's a lot that we have to go through to do that. So I think that's everything. So hopefully that helps. We're going to switch it back to our video here. And so hopefully that was useful for everybody. Hopefully you gained some insight. We're going to open it up for some questions. I don't know right here. It's just this one. Somebody wrote on here, evidencing, is that right? Did somebody put that in there?
Yes. Let me see here. Oh,
Did you scroll up even more? Is there? That's it. That's the top. Okay, so there's a question here that says, can you use a bank statement in lieu of a confirmation letter evidencing titling? Absolutely. Yep. So a bank statement is just as good. The bank statement, as long as it shows title on the bank statement. So what I mean by that is, nowadays a lot of us do everything online. And so if we go in and we just print off from our computer our most recent Wells Fargo, summary, it won't show title. It won't show ownership on that. What you want is confirmation of how that account is actually titled and owned. So you want the actual statement that the bank would typically mail you to show the trust name on the statement. So, but yes, that would suffice to have that. So is that the same question? Okay, so that's just that question. Okay, so then we're here. I have property in LLC. Do I need to take them out of LLC to train? Oh, great question. That's another asset that I didn't cover. So I'm glad that you brought this up, Corley. Some of you have LLCs that may have rental properties in them. And that's a great vehicle to use for rental properties. It gives you a layer of asset protection. So if there's lawsuits or something like that, these LLCs will provide asset protection for you. So that's the best place to hold rental properties in the form of an LLC. Well, an LLC is an asset, right? It's worth something. It's worth the value of the rental property. So if I have a $300,000 rental home inside my LLC, the value of your LLC is $300,000. An LLC is made up of what we call a member and a manager. The member is just a fancy legal word that means the owner of the LLC. It's who owns that LLC. And the word we use for that is member. Why they didn't just call it an owner, I don't know, but that's the word we use. And the manager is the person that manages the LLC on a day-to-day basis. So if we have this LLC that owns a $300,000 rental home, and the owner or member of my LLC is Dave Eastman, and I become incapacitated or I die, then once again, I have a $300,000 asset that exceeds the probate threshold amount of 75, or for real estate, it's 150. And therefore, if my wife or my kids or whoever want to become the legal owners of the LLC, we have to once again go through a process called probate because we're over the probate threshold amount. So the rental property should be in the LLC. That's the right way to do that. But then the owner or the member of the LLC should be our trust instead of me. So how do we know who the member of our LLC is? You filed what are called articles of organization with the Arizona Corporation Commission when you set up your LLC. And you should have those articles that were filed, that were recorded, and they have a stamp at the top. You should have that in your LLC binder or book. And you should look at that and it will say the member of your LLC is Mrs. Smith or Smith Living Trust. What we wanted to say is Smith Living Trust as the owner of the LLC. And that way, when death or incapacity occurs, we have no issues. The trust would be the owner of the LLC. So great question. Appreciate you submitting that. Any other questions that we have? That's it. Okay. Well, hopefully this was worth everybody's time and you gained something from all of this. We do have a raffle drawing for everybody that is on our call today and participating. So I'm going to show you. I'm not sure if you can see that. Here are the names. Shuffle these around a little bit and we'll do a quick drawing. Not looking. I'm not going to play favorites here to any of you wonderful clients. And we have Karen Culp. So Karen, you are lucky winner of our gift basket and we have your information. So we will send that gift basket to you, Karen. So thanks everybody once again for joining us for this Zoom call. We're going to be doing these monthly. Elisa has been great at setting these up. Hopefully you enjoyed our newsletter that she did for us in March with those recipes. I can attest to Elisa's recipes and her cooking. I've eaten lots of her meals and they're delicious. And we'll have another one coming up in April and hope all of you participate in our Zoom call in April. Until then, stay safe and we'll see you soon. Thanks. Bye.